everyone. My name is Jie Huang. I am a senior associate at Scott Legal PC. Today, we are going to spend some time to discuss what are the different visa and green card options for investors and entrepreneurs. So just a few things before we get started. Scott Legal is a full-service immigration law firm. We do assist individuals and businesses in a wide variety of circumstances, including employment-based visas and family-based visas. We are able to assist whatever your immigration needs may be. As some of you may know, the firm itself was founded on an E-2 visa, so visa options for investors and entrepreneurs is our specialty. Just a few announcements before we get started. We will be continuing these webinar series, doing at least 2 webinars a month on different immigration law topics. At the end of this webinar, we will be sending out to all participants a few things. First, we will be sending you a PowerPoint that we will be using in this webinar. We will be also sending you a comprehensive visa guide covering all the visa types that will be covered in this webinar. We will also send you a link where you can sign up for any additional webinars in the future, and also a link to this webinar as it will be recorded. This webinar will also be available on YouTube, and we do encourage you to subscribe to our YouTube channel as we regularly upload immigration law related videos. Finally, we will send you a link where you can follow to set up a consultation with one of our experienced lawyers if you wish to discuss your case further. So today, we are very lucky to have Dustin Saldarriaga, who is a senior associate at the firm with a wealth of experience assisting investors and entrepreneurs in a wide variety of visa categories. Finally, for any questions that you may have, please do feel free to put them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us move into our main presentation. Hello, Dustin.
Hi, GA. Thank you very much for the introduction. So today in this presentation, as GA mentioned, we'll focus on a few of the most common investor visas that our firm handles. First, the E-2 non-immigrant visa. Second, the National Interest Waiver for entrepreneurs, which is a green card, the EB-2 preference. Third, the International Entrepreneur Rule, which is not a visa or a green card. It's actually parole, and we'll talk a little bit more about what that means. And finally, the EB-5 investor green card, also known as the millionaire's visa. So to start, let's talk about the E-2 visa. The E-2 visa is a wonderful option for anyone who wants to develop or direct a business in the US and who has the nationality of a treaty country. So basically, there are dozens, about 80 countries around the world that have signed treaties with the United States. And if you have a passport from one of those 80 countries, then you can apply for one of these visas, which essentially will allow you to invest either through starting a business or buying a business or even starting a franchise in the United States. The investment amount is far lower than for an EB-5 visa. For an EB-5 visa, it starts, as we'll talk about in a minute, at $800,000 for an EB-5. For an E-2, the amount that's required depends on the type of business, but is typically around the $100,000 mark, and we'll talk more about that in a moment as well. So, as I mentioned before, if you look at your presentation, the first requirement is you must have a passport from a treaty country. You can Google U.S. Department of State E-2 treaty countries to see a full and updated list of the countries that are on the E-2 treaty country list. You must make an investment either through a startup or by purchasing a business in a U.S. company. The funds that you use must be at risk, meaning you have to actually spend the money on the business. If it's a startup, you actually need to have spent it on things like leasing an office space, buying furniture, buying office equipment, marketing, paying employees. The money cannot simply be sitting in a business bank account, for example, as working capital. It's okay to have working capital, but working capital won't in and of itself satisfy the investment requirement. The government will also want to see where you got the funds that you're investing in the business. And frankly, you have a lot of options for this. So really, the government is more looking for illegal sources of income. So as long as your source of funds is legal, it's most likely fine. The exceptions to that are if you are using a loan that is secured by the business itself, you cannot do that. And you also cannot use retained earnings that remain in the E2 business. So if you want to use, if you've had your business going for a while, you actually need to distribute those funds to yourself. You need to pay taxes on them, and then you can invest them back into the company. We'll talk about what a substantial investment is. And in other words, what that means is how much you need to invest for the E2. We'll talk about that in the next slide. Typical expenditures for an E2, I already mentioned a few: office space, inventory if your business sells items, office equipment, printers, computers, phones, a website, marketing, it could be Facebook ads, Google ads, things like that. And setting up the company. So for the E2, in contrast to the EB5, you can count legal fees, you can count fees that you spend to set up the company, administrative fees. You can count all that toward the E2. So the E2 really is, if we have a client who is a national of an E2 treaty country, the E2 would be the first option we consider, just because it really is a great option. And we'll get to the other requirements in a second. I did also want to add that the visa can be issued for up to 5 years, and it can be renewed indefinitely. And family members also, the spouse can work automatically upon entering the country. So what are the other requirements? The business cannot be marginal. What this means is that the business must be able to support support at least 3 to 5 full-time equivalent U.S. workers within a 5-year period of starting operations. So a marginal business is one that can only support the visa applicant. So you cannot only support yourself. You actually need to employ at least 3 full-time equivalent U.S. workers within 5 years. The business must be real and operating. So it is important that you show that you've actually purchased everything that the business needs to be operational before you attend your visa interview. So the consular officer will want to see, for example, that you have all the licenses that you need to operate. So if you're starting a restaurant, the consulate will want to see that you actually have your license from the Department of Health of the relevant state, so you can start selling food. If you're starting a liquor store, they'll want to see you have a liquor license and can start selling liquor. You want to have everything lined up so that once you get the visa, you can come to the US and start operating the business. And again, that works with the investment requirement. So part of the investment requirement is showing that you actually have bought everything you need for the business to be operational. You don't need to employ employees before you apply. It's okay to apply with a business plan that shows that over the 5-year period after you start operations, you will have 3 full-time equivalent workers. So other examples of the business being real and operating, we do always recommend that you have a signed commercial lease before you apply. And obviously, you'll want to show that the business has been established. So you'll want to start the LLC or the corporation. You also would want to show that you have a website. So one thing that consular officers will sometimes do is actually go to your website during the interview and see if it exists. So you want to show you have that. And finally, if you have contracts with customers or prospective customers, that is a great thing to show in your E2 visa interview and application. You must be coming to the US solely to develop and direct the E2 enterprise. So when you enter the US on an E2 visa, you only have work authorization to work for the E2 company. You also need to be qualified to develop and direct the company. So you need to show in your application through a resume, for example, that you have the educational background or the experience that's necessary to run this business. And usually that's not a problem to show that. We tend to be good at working with our clients to show how whatever experience they have, it's relevant to what they'll be doing in the US. You must own at least 50% of the E2 company. You can own 50%, meaning you can have 2 E2 investor visa holders for a single company, but you can only have 2 maximum, because as soon as you drop below that 50% mark, you become ineligible for the E2 investor visa. And finally, you must have the intention to return home upon expiration of the visa. So the E2 visa is not a green card, it's a non-immigrant visa, meaning that you need to leave the US once your visa status expires. This is not hard to show. Typically, it's just a signed statement that you intend to depart at the end of your visa, your status. The thing I would say, though, is it is fine to renew your status if you're in the US. It's also fine to renew your visa, and we handle those applications very often. And as GA mentioned, our firm was established on an E2 visa, and Ian, our founder, continues to renew his without any problem. So as long as you remain eligible, you and your business remain eligible, there's not a problem renewing the E2 indefinitely. One of the most common questions we get from people considering an E2 is, how much do I need to invest? And the government does not publish a dollar value like they would for the EB5. For the E2, they say you need to invest a substantial amount. And a substantial amount really does depend on the type of business, where you're applying, and the overall strengths of your case. So just to take an example, if you are starting a law firm like ours, law firms are very cheap to start. You just need a few computers, you need an office space. You may need to get certain insurance, but relatively speaking, the cost is very low, meaning $50,000 or less. If you're starting a manufacturing company, you might have to invest a lot more to get that business started. So the way the government considers this is they call it the proportionality test. The less money a business costs to start, the more of that amount the government will want to see invested. So if you're starting a law firm, and the startup cost is $50,000, the government will want to see that you have invested all of that amount, 100%, and maybe even more. Typically, we try to get our clients to $100,000 just for security, but we'll get to the holistic piece in a moment and talk about when the amount's less than that. If you are starting, for example, a manufacturing company and it costs $10 million to invest in all of the machinery, the employees, et cetera, the government might not expect for you to invest 100%. They might be okay with you investing, say, $6 million of that $10 million. So only 60% of the required startup. So that's what the proportionality test is. In terms of where you apply, certain consulates do tend to see larger businesses, and we work with our clients to figure out where they may be eligible to apply and strategically where would be best. And finally, the overall strengths of the case. So if you say you're starting a low-cost business like a law firm, you've invested $20,000 and you really can't think of anything else to invest in that business, the first thing we would do is see if there are opportunities to invest more. You could potentially invest more in marketing. Typically, marketing is an opportunity to put more money where you actually do see a return for the business. We might encourage you to pay 6 months or a year of your lease in advance to bolster that amount. But if really you cannot invest anything else, then we'll start to look at the application holistically. And what that oftentimes means is to think about other areas where you can strengthen the application. And just to give an example, one of the areas that is clearest in terms of bolstering an application that may have a low investment amount is to hire an employee. If the business is already employing an employee, then other parts of the application, such as the investment amount, become less critical. And the reason is that at the end of the day, what a consular officer is looking for in an E2 is a company that will employ US workers. So if you're able to show that you already employ US workers, in spite of the fact that you haven't invested a significant amount of money, then you kind of overcome that hurdle, that even though I haven't invested an enormous amount in the business, I'm already employing a worker. Therefore, we have accomplished our goal. Even though the investment amount is relatively low. So that's what we mean by look at the application holistically. And you can show that in other ways. You can show, if you've invested a low investment amount, but you have letters of interest from significant clients who want to do business with you, that also could take the attention from the investment amount and show that in spite of the low investment, you really will be generating sufficient revenue and profits to employ workers. And I should add, we actually, the bulk of our E2 cases are on high risk cases, such as those with low investment amounts. So we do specialize in those. We work with clients very often on those. You can, as we mentioned before, you can buy a business. The value of that business would be typically the fair market value of the business. We usually want to see that the business was marketed to the public, which usually, if the fair market value is paid, that's not an issue. You've satisfied the substantial investment requirement if you've paid that amount. And franchises are also a good option. And the reason for that is that franchises come with a track record. If you're starting a Subway sandwiches, that's a franchise that the government knows that Subway sandwiches, okay, you tend to do okay, right? You tend to already have your marketing in place. People know what Subway sandwiches is. Versus a startup where you really do need to rely on that business plan to show that you're actually going to accomplish your targets. And, even a franchise, you should include a business plan just to show that you've thought about your territory, you've thought about, how you really are going to hit those goals in terms of revenue, profit, and employment. We talked a bit about common good E2 visa expenditures, inventory, equipment, furniture, etc. Bad E2 visa expenditures tend to be travel expenses. If you come to the US looking for a business, don't put your flights in your application. Don't put your hotel fees. If you entertain prospective partners or clients, don't put that in your application. The government is really looking for money you've spent to really invest in the business and grow the business itself. And we can talk more about that through a consultation if helpful. Finally, for startups, if you do really want to show the government that you've invested enough for that type of business, you can include a letter from a certified public accountant or CPA who says, I am a certified public accountant. I've looked at what has been invested in this business and how much is usually required for this type of business, and a sufficient amount has been invested here. You can also include business articles. So an example I like to use is I worked with a client who was starting a tattoo parlor, and we included trade publications talking about how much it costs to start a tattoo parlor. And we included those in the application to explain to the government that the applicant had invested the amount that's typical for that type of business. And that was sufficient for that application. So with that, I will pass it off to GA to talk about the National Interest Waiver requirements.
Sure thing, Dustin. Before we move on to the NIW, I think we have a question in the Q&A box that could be relevant to the E2 that we just discussed. So maybe we can answer that before we move on. Will an applicant need to show cash for living expenses before the business is sufficiently profitable and I'm assuming when they're applying for the E2?
Yeah, so really good question. The answer is generally no. Really what the consular officer is looking for, they're going to look at the financials of the business, and basically they are going to see what are the revenues that this business will be taking in, what are the expenses, and what are the profits. And your expenses would show, you're going to show in your business plan a 5-year projection. So you're going to show all that information, revenue, expenses, profit, estimated for the next 5 years. And so payments to employees, you would show that under your expenses. And in terms of your ability to support yourself, typically what the government is going to want to see is that there's enough left over in terms of the business's profits to support you. So if you're taking a salary from the business, then that could be in expenses. But usually what we see is that the business has a certain amount of profit at the end of the year after it's paid all its salaries to employees, other employees. And then you as the owner will be able to draw from the profits that the business generates. And so that's how you'd show that you have sufficient cash flow for living expenses, is from the profits of the business. And usually you don't have to show a lot. If you're able to show that in the first year or two, you're hitting $35,000 that you're able to use for yourself and your family, that's usually okay. And the government isn't going to necessarily require that in year one you're generating a lot of money. It's okay to take a hit in year one just to build the business. If you can show that over the next 5 years, by year 5, you really are going to hit that mark where you're able to comfortably support your family and yourself and pay all your workers. And on that note, when we say you need to hire at least 3 full-time equivalent workers within 5 years, the earlier the better. If you can start hiring in year one, if you can start hiring before you apply, that's ideal. A lot of people and most applicants don't. They'll start hiring in year one, maybe year 2. And ideally no later than year 2. If you have to, it can be approved, but you would really want to focus in that business plan on how you're going to ramp up that employment as soon as possible for the business.
All right. Thanks, Dustin. That's very helpful, certainly. Okay, so then maybe we can move on to the National Interest Waiver, and that is a green card category. So what is an NIW? So the NIW is a subset of the EB2 green card, employment-based green card category. But what makes this a very attractive option for entrepreneurs is that someone can self-petition for this green card, as opposed to other categories of the EB2 or EB3, where you need an employer to sponsor you, a US-based employer to sponsor you. Usually that option is not available for entrepreneurs because they have an ownership in the company that they run. However, for the NIW, an individual can self-petition for the green card themselves. So this makes it a very, very attractive option, similar to the EB1A, which some of you may be familiar with. The EB1A option also allows self-petitioning, but that requires a much higher threshold of international and national acclaim for the individual to be able to benefit from it. But the NIW EB2 category could be a much more accessible option. Okay, so maybe let's go then to look at the requirements of how you can qualify for an NIW green card. So to qualify, first you need to satisfy the threshold requirement to take advantage of the EB2 category itself. And by that, the government requires that you either have an advanced degree or have exceptional ability in your field of endeavor. So now let's unpack that a little bit. So advanced degree means a master's degree or higher. So it definitely includes the master's degree or a PhD degree, and it also needs to be the equivalent of a US master's degree or PhD degree. But also you can meet this by other kinds of degrees, such as a JD, an MBA, or an MD even, which requires that you already have a bachelor's degree in order to get that degree. Also, it is also possible to meet this requirement by having a bachelor's degree in your field and by showing 5 years of progressive work experience following the bachelor's. That is also considered the equivalent of a master's degree. So for example, let's say you have a bachelor's degree in engineering, and if you had 5 years of experience in working at an engineering firm where your duties and your position changed over time to a more senior level. And that progressive change is very important if you're trying to meet this threshold through a bachelor's and 5 years of experience. Because if your duties were the same and your job title was the same, your salary stayed the same, such that there was no change in the variety and advanced nature of the work that you've did, then the government will not see that as progressive work experience. So you may not be able to meet that threshold through a combination of your degree and experience. However, for example, if I started off as a junior associate and then I become a senior associate, and then 5 years later I become a partner, that is certainly progressively changing, advancing degree of work experience that you have accumulated, which would be sufficient to meet this requirement. So then now let's talk about exceptional ability, which is another way you can meet the EB2 threshold requirement. And to show exceptional ability, there are a number of evidentiary criteria. You just need to meet 3 out of the 10 criteria that's on there. However, just meeting that criteria is not enough. You also need to show that you as a professional are operating at a level substantially above your peers in in the same field that you're active in. So for that, I would say if you're meeting the requirements through exceptional ability, that is definitely a fact-specific inquiry. So definitely get in touch with us. We will look at all of your facts to see if that could be an option for you. But for now, it is worth it to know that even if you do not have a bachelor's, even if you do not have a master's, there is still a third pathway to qualify for the EB2 threshold, and the NIW could be an option for you. Now, the second part of qualifying under the NIW green card category is showing that you can meet evidence under 3 of the matter of Danazar prongs, which are really the criteria of that the government uses in thinking about why and how this person is eligible for a national interest waiver. And the requirement really is that first, the work that the entrepreneur is proposing to do in the United States must have substantial merit and national importance. And by that, it means your work will not just benefit your immediate employer, immediate clients. Your work will not benefit just your company and your livelihood, but what you are offering to the market as a whole will really generate benefits that are larger than that will, for example, advance an area of technology that the U.S. government finds critical to its national security. For example, like sustainability is another great example of an area of technological advancement that the U.S. government finds very, very important. And if your business is bringing something new and innovative to the field such that not only do you affect your immediate clients who use your services, you will end up contributing to the pool of knowledge in a way that results in how things are being done in the field, improving to some degree. That is a very attractive case for a national interest waiver, because then you can show broader impacts than just running your own business and benefiting your clients. So the second prong for the matter of Danazar factors is that, are you well positioned to advance the proposed endeavor? And the reason why the government asks about this is because you could have the best idea in the world, but if you do not have relevant experience or expertise or knowledge that is relevant to what you're proposing to do, then the plans, the lofty plans that you have to contribute to matters of national interest becomes a weaker argument, right? So to really meet this prong, what you want to show is a track record of success in similar and related endeavors that really position you as the right candidate to carry out your plans in the United States that is of substantial merit and national importance. Now, the final and third factor is whether on balance, it would be beneficial to the United States to waive the requirements of a labor certification for you, to let you come into the US and perform your work, the proposed plans, as opposed to letting someone else with the minimum requirements, the same educational requirements to handle this work for you. And the way to really meet that is really hone in to what the broader benefits are of your work and how you have the unique credentials to really make this work shine, as opposed to just someone else who has the same degree as you, who can be replaced in the United States. So the more unique strengths that you can really bring out in your application, the stronger your argument will be on the third prong. And it is worth mentioning that for entrepreneurs, there is another piece of information we can use in favor to argue for this third prong, which is that the reason why Congress thought of the labor certification requirement in the first place is for the policy of protecting the U.S. labor supply. But in the perspective of entrepreneurs, you're not taking away a job from a U.S. worker. By contrast, you are actually creating more jobs to hire more employees, which could even end up generating more jobs than if someone else in the US took your place. So for entrepreneurial endeavors, it is a very strong argument that we have, if we can make it, in terms of the interests of having the labor certification itself is better served, actually, in this case, by waiving the requirement for the entrepreneur, so the entrepreneur can come and generate even more jobs than another person would have been able to do. Okay, so maybe let's then move on to the next slide. So how the National Interest Waiver can be used for entrepreneurs. Now, and here we can talk about several changes in the case law that really made it more favorable and more accessible for entrepreneurs to use the NIW as a green card option. So the first point is that before matter of Dinosaur, which is a AAO case law, came down, the benefit to the United States had to be of a national geographic scope. So the benefit to the United States of an entrepreneur's endeavor was measured in what areas the entrepreneur's work touched. By contrast, after matter of Dinosaur came down, the benefit could be local. So you could only have a business in a certain state and in a certain region, but the benefits that you have by running your business in that specific state could still be thought of as important enough to meet the first prong, substantial merit and national importance. So what that means is now, even if your business is smaller and limited to one geographical area, you can still arguably be thought of as someone who will be bringing benefits of national importance. The second change that came from the new case law is that matter of Dinosaur specifically noted that entrepreneurial work is a good candidate for an NIW just because, and in addition to all the other reasons that we talked about, precisely because entrepreneurs are not able to use the traditional labor certification pathways for green cards because they have ownership in their company. And finally, the final advantage that really could make the NIW a good choice for entrepreneurs is that entrepreneurs are usually self-employed, and therefore the ability to self-petition is really it can really be the make or break factor in making an option available for an entrepreneur to use. All right, so now let's go over a case study for entrepreneurs, which could really show how a specific case can meet each of the three requirements to qualify under the NIW category. So in this case, the entrepreneur proposed to set up a small consulting firm, and the consulting firm was focused on running projects with diverse organizations for the purpose of improving veteran services and wounded warrior care. So what the person proposed to do was to coordinate projects to facilitate the reintegration of returning veterans and wounded warriors into a productive society in the United States. And so this person prepared a comprehensive business plan, and in that business plan, they included a description of how the particular business's support and advocacy will improve existing program offerings. And the business plan also included specific business partners that the business would work with. For example, various philanthropic organizations that are already active in the US, government entities, and other businesses. And to further support the national importance of this endeavor, the applicant submitted government reports, news articles, letters from senior officers in military, government, businesses, and philanthropic organizations describing what are these gaps in current services offered to veterans care and why were there significant public interests in this work. With regards to how this person was well positioned to advance the proposed endeavor, what really helped was that this person had a very remarkable record of success in past endeavors in the UK, which was where this person was from. And this person was able to get letters from senior officials from government in his home country who had worked with this person. And in those letters, what was described was how this person played a leading role in developing and implementing initiatives to connect public and nonprofit organizations in the UK and the US to benefit those areas in wounded warrior care and veterans priorities. And some of the articles, some of the letters had specific testimony about this, saying without this person, we would not be able to have the success we had in really facilitating those veterans to reintegrate into society and find the jobs that were right for them. So throughout these letters, it was really made clear that this person had a high level of understanding and a very high level of network connections in the US and UK charitable sectors that no other person could bring. So this person clearly had unique strengths that could not just be replaced by another US worker in that field. Finally, the scale of some of the projects that he had led before was large. And some of the testimonial letters talked about how this person's work in particular enabled millions of dollars in charitable efforts being productively connected to these concrete initiatives that really helped veterans improve their lives. So all of these testimonials, together with a detailed business plan, together with letters of intent from clients that were willing to work with him if he came to the United States, really painted a picture that there was significant public interest in this work that this person was proposing. And so the government was ready to find that this person was indeed well positioned to advance this proposed endeavor. Now, for the third prong, on balance, beneficial to waive the requirement of this job certification so that the entrepreneur could come and do this work. This was supported by the argument that this person, being an entrepreneur, he was self-employed. And so it would be impractical for this person to rely on the traditional labor certification green card pathways just because he wasn't eligible, having had ownership over his company. Now, another thing the government relied on was the immense value, the broad value of improving services to veterans, really the contributions to social justice that went beyond just helping his immediate clients, but improving the lives of numerous veterans in the process. Finally, this person's past record of success really showed that he had unique strengths and unique experiences that could not just be replaced by someone with the minimum qualifications that he had. This also supported that he would be well positioned to run this endeavor, and because he was so well positioned, it would be beneficial to waive the requirement for this individual so that he can come and do this work of high importance.
Great, thank you, GA. So now we'll switch to initial parole, which is part of the International Entrepreneur Parole Rule. So the International Entrepreneur Parole Rule, I'll call it IEP, was initially launched in 2017 under the Obama administration. It was relaunched in May of 2021 under the Biden administration. For almost its entire history, there had been basically no movement on the IEP. And only recently have we learned that apparently the government has started reviewing these applications, and it is taking about a year from the date of application for the government to review these. But we are aware of other practitioners, other lawyers who have started getting responses on these applications. And again, it's only a handful. So the government is not moving fast, and really we're not seeing a ton of movement, but there appears to be some movement on these applications. So, excuse me, what is IEP? IEP is parole. So it is not a visa, it is not a green card. What parole is basically when the government allows someone to enter the country for a very specific purpose. And when someone's admitted on parole, they cannot technically change status to another status, and they cannot technically apply for a green card. They need to do that at a consulate. So they need to leave, apply for the visa, and come back in. So parole really, again, is for a very specific purpose. And what the International Entrepreneur Entrepreneur Parole rule does is it says that people who are who want to come to the US to grow a startup that has a substantial potential for rapid growth and job creation, that they can be admitted into the US to do that for a period of 2.5 years. And at the end of that 2.5 year period, they can apply for another 2.5 year period of parole for a total of 5 years. Who would consider this? Really, this is for people who, again, based on what I said before, we usually would opt for E2. So if you are in a national of an E2 treaty country, almost always the E2 is going to be a better option than IEP. IEP would be an option for those who do not have E2 treaty country nationality and who want to start their own business in the US. The other group of people who might benefit from IEP are those who expect for their ownership stake to be diluted. So for IEP, you don't need to own 50% of the company as you would in an E2. For an E2, you only need to own 10% of the company for the initial parole period, and then for that initial 2.5 year period. For the second 2.5 year period, your ownership can drop to 5%. So if you are not a national of an E2 treaty country, or you're not going to own 50% of the company, IEP parole really is going to be one of the options you'd want to consider. Now, as I've suggested already, it does come with its risks. A denial cannot be reviewed, and also you can lose parole if you become ineligible for it. You can lose it quite easily. However, the positive side is if you do qualify, you could stay in the US for 2.5 years to grow your business. Your spouse could apply for work authorization. And so for some people, it really could be the best option. So let's talk about the requirements. You see those on your screen. So basically, at the end of the day, really what the government wants to see is in this first bullet, that the business will provide a significant public benefit to the US, and that the business has substantial potential for rapid growth and job creation. So what you need to show to qualify for that initial 2.5 year period of parole is that you own at least 10% of the startup and you have an active role in it. This is not an opportunity for a passive investor. You have to be active. The business needs to have been established in the US within the past 5 years of applying for parole. And it needs to show that it has demonstrated potential for rapid growth and job creation. It also needs to have received a certain amount in investment. And that amount currently is $264,147 from qualified US investors or government funding of at least $105,000, $105,659 in grants or awards. This final bullet's important because basically what the government's doing is it is saying we are going to look to the funders to basically vet these businesses. The government acknowledges it's not the expert when it comes to figuring out what companies are likely to have rapid growth. Instead, venture capital firms, startup accelerators, or government agencies that fund these types of businesses, they are the ones who have the expertise. So basically, USCIS is going to look to those entities to decide, okay, have they gotten the funding? Have they convinced venture capitalists that they're going to do this? If they have, we're going to essentially take the venture capitalist's word for that. The qualifying investor must be majority owned and controlled by US citizens or green card holders, and they must have established a successful record of investment. That means you cannot have a wealthy uncle who funds your startup and puts that $264,000 in it. This really does need to be money that is invested by a firm that does this, as part of its business. Again, the government's looking to those firms to make sure this is a qualifying business. So if we look though, let's quickly Okay. So that third bullet, in terms of the required investment, you do have an alternative. So if you have not received the full 264,000 from a qualifying investor, you can provide alternative evidence, and this is beneficial for those who are applying if you haven't received that full amount. You basically want to provide any evidence that is reliable and compelling, that shows that the business has a substantial likelihood of rapid growth and job creation. The application instructions list a lot of examples of evidence that you can provide, but just to go through some examples, and this really is a chance for you to highlight what you personally have done as an entrepreneur, as well as what your company has done. So documentation showing your academic background, your ability to grow and build the startup, past experience you have growing startups and creating jobs, evidence of the businesses being selected to reputable startup accelerators, so like Y Combinator, things like that, incubators, national impact of the business, the scope, the social impact of the business. You can include your tax returns, the business's tax returns that show that it employs workers, that show that its revenues and its profits have increased over the time since its creation. Evidence of other fundraising. So even if you have received funds, say from crowdfunding, from family members, you can show that. It's not going to satisfy the qualifying investment requirement, but you can look at the alternative standards that are on the screen now, and you can point to, hey, you know, we've done a lot, we've employed a lot of workers, we've had a significant impact, and we have received funding from crowdfunding, for example. So holistically, you could include that. Letters from government agencies or really any organizations that can talk to your skills as an entrepreneur or the business's importance, any press coverage that celebrates you or the business, and patent awards. So again, these are just a few examples of what you can include in the application in the place of that third prong, the qualifying investment prong. The process is basically you would file what's called a form I-941 with USCIS. You would also do your biometrics, fingerprints, etc. And then you would go to a US consulate for a boarding foil. Again, this is parole, it is not a visa. So you would get a boarding foil, and with that, you would approach the port of entry to the United States. And it's up to Customs and Border Protection whether to allow you to enter the US on parole. And once they allow you in, you essentially do have parole. Again, it's for a very specific purpose. It is not considered an admission for purposes of changing or adjusting status. Again, you'd have to do that at a consulate abroad. Just to quickly cover some frequently asked questions, the ownership stake for initial parole, that first 2.5-year period, you do have to own 10% of the business. But after you're approved, your ownership has to stay above 5%. So you can dilute your ownership stake to some degree. It just cannot drop below 5%. And then for re-parole, so the second 2.5-year period, you need to own at least 5% of the business. And then after you've received re-parole, the second period of parole, your ownership share can drop below 5%, but you still need to own at least some of the business. You do not need to personally invest in the business. So this is another example where, you know, it's a benefit over E2. Is if you don't have funds to invest in the business, all of your funding is external, then E2 is not going to work for you, but Entrepreneur Parole could. How many people can receive parole from one startup? Up to 3 entrepreneurs from a single startup can receive parole. And can you adjust or change status? Again, you cannot. You need to leave and apply for that at a consulate. So, you know, frankly, our firm does not do many IEP applications. And the reason for that is that the government has not moved on them until very recently. And we oftentimes try to find other alternatives for our clients instead of IEP. That may be E2, that may be an EB5, which we're going to talk about in a minute, but could be an IW like what GA was just presenting on. But in general, IEP is an option for I'd say a very select few people, given the constraints and the government's lack of movement on it. But hopefully we will see more movement by the government on these applications. So with that, let's turn to our final category, which is the EB-5 green card. Many people know about the EB-5 through its nickname, which is the Millionaire's Visa or the Millionaire's Green Card, because it does have a clear investment amount. You have to invest as of today, as of now. This amount does change. It was recently updated. You have to invest at least $800,000 into what's called an NCE, new commercial enterprise. And 800,000 is if you can establish that the business exists in a targeted employment area. So that's either an area with high unemployment or an area that's rural. You get that lower amount, that 800,000. If you're not starting a business in a TEA, your investment amount needs to be $1,050,000. Now, new commercial enterprise, the name is misleading. That term was introduced when this law was passed decades ago. So a new commercial entity technically is any business that was formed after 1990. So almost any business, there are obviously some businesses that existed before then that people would apply for an would consider an EB-5 one, but by and large, you know, now that we are 32 years since 1990, most of the businesses we're looking at qualify as NCEs. Now, to take a step back, just to make a couple quick notes, we do work with clients who move from a non-immigrant visa, like an E2, to an EB-5. So if you have an E2 business that you've been investing in over time and you've been building the number of jobs in that business, that could be a candidate for an EB-5. So when clients come to us with an E2 and they say, you know, I'd like to consider a green card, the EB-5 would be one of the first options we'd consider. And the other preliminary note that I'd make is that there are two options within the EB-5. When you're applying for an EB-5, you're either doing a direct investment in a company that you essentially manage actively. So you could be starting a restaurant and you're investing that $800,000 or that $1,050,000 into your restaurant, and you're going to build the necessary number of jobs in that restaurant. That is a direct investment EB-5 business. The other option is a regional center application. So essentially what that is there are regional centers that essentially, usually what they do is large projects. It could be building a large hotel. It could be building a new subway station in a city. These are projects that take tens of millions, if not hundreds of millions of dollars, and they bring in dozens, if not hundreds of EB-5 investors, and each EB-5 investor would put the necessary investment amount, whether 800,000 or 1,050,000, into the regional center project, and the project will be creating hundreds, if not thousands of jobs. And so divided by those jobs, divided by the number of regional center investors, you get your required number of jobs for job creation. And the regional center option tends to be much more passive than the direct investment option. And so for that reason, it is attractive to many people. The things to know about the regional center option are that it does sunset. So, for example, last year it was paused for months, and that caused a lot of stress and anxiety for many people. Fortunately, the government did renew it, and it should not sunset until 2027, I believe. So we do have some time. And if you apply before 2027, I believe in the law, it does say that they will adjudicate those applications and not pause them if you apply before that date. So let's go through some of these bullet points. So we already talked about what is an NCE, new commercial enterprise, a targeted employment area, high unemployment, or a rural area. What investments can be included? So basically, money needs to be at risk needs to be committed to the business and specifically for the purpose of job creation. So that could be buying equipment, buying furniture, a lease agreement, paying a lease, or obviously paying employees wages. But in contrast to the E2, administrative fees cannot be included in that amount. So if you pay lawyers $30,000 as part of setting up the business, for example, that is not part of the $800,000, for example, that needs to be invested. Excuse me. Also, if you're buying a business, money that you spend to buy the business is not considered in the required investment amount. And the reason, again, is that those funds need to be available for job creation. So if you're buying a business, you're paying a business seller, those funds are going to the seller. They're not being made available for you to actually invest in creating jobs for workers. I know we did get a question at the beginning of the presentation. Essentially, it's a great question. And the question is, do I need to invest the full amount before I submit the I-526? The answer is, unfortunately, it's complicated. In general, you do want to apply once all of the required funds are at risk, and meaning that they have been committed to the job creating entity. That's the general rule. There are some exceptions. You, for example, may be able to use escrow. You may be able to use a promissory note. Those get into quite complicated territory. And before you apply, you definitely want to talk to an attorney about how to make that work. But in general, you do want to have invested the funds, made them at risk for the job creating entity before you submit the I-526. But I would encourage, if you do have questions about that, schedule a consultation. It can be complicated, and there's really not a simple answer to that question, which is a great question. So now the investment does not need to be made all at once. So it should be made ideally before you submit the I-526. But for example, in the case of an E2, if you've invested the funds over the course of 5 years, 6 years, they could all go toward the investment amount for the EB5. So you don't have to make one lump sum $800,000 investment, for example. Now, the investment cannot include retained earnings. So if you have an E2 business and it retains its earnings and uses those to hire more workers, and you have 10 workers, but they're funded through retained earnings, that's not going to work. You have to actually show that you have invested your personal funds into the NCE. So if you have an E2 business that's generating returns, you want to distribute those to yourself. You want to pay taxes on them, and then you want to put those back into the business, and that would count for the EB5. But you do need to actually go through the process of distributing the funds to yourself, showing that they are your personal funds that you're then investing into the business. Now, challenges for EB5 direct investors, the source of funds. This is a huge hurdle. Essentially, USCIS does a full financial audit on where the funds came from that were invested into the business. So keep very good records. It's nothing like an E2 application. It's far more detailed. Now, you also need to make an equity investment. So you can't, for example, this can't be a loan. You cannot have a guaranteed return on your investment. You actually need to commit the funds to the business, for example, by purchasing shares, something like that. Job creation. You must create 10 full-time jobs within the 2 years of the I-526 being approved. So these must be full-time equivalent roles, and they must be US citizens or lawful permanent residents. You want to have very clear documentation that you're meeting this employment requirement. For example, have I-9s, go through E-Verify, so that you have clear documentation that you have legitimate full-time workers to satisfy this requirement. And again, the investment needs to be linked to job creation. So you need to show you put the money in, how the money was spent to create those 10 full-time jobs. A detailed business plan, if you don't already have those jobs by the time you submit the I-526, you want to show through a business plan how you're going to create those jobs in the 2 years after the I-526 is approved. Why 2 years after the I-526 is approved? So this gets at the process, the filing process. You would first file an I-526. Once that is approved, and now with the new law, you actually can file an I-485 at the same time. The I-526 is the EB-5 application. Essentially saying that you're qualified to apply for the green card. The I-485 is the application for the green card. Now, the benefit now is that if you look at the visa bulletin and your green card is current based on your nationality, where you were born, you can file the I-526 and I-485 at the same time. And that's important because when you file an I-485, you can also apply for work authorization and travel authorization. So in the past, you'd have to wait for your I-526 to be approved and then apply for an I-485. Now you can apply for both as long as the green card is current for you, which is it's a big advantage for applicants. When your I-485 is approved, you essentially get conditional green card status for 2 years. At the end of that 2-year period, you're going to file an I-829 application to remove the conditions. And essentially what the government is looking for is proof that you've actually created those 10 jobs. So the government gives you conditional status saying, create the 10 jobs, then we'll remove the conditions. You'd file the I-829 to remove those conditions. And that's why you have that, that 2-year period for the employment figures. So we got a very good question. How long is the processing time to get approval of an I-526? If you ask the government, they will tell you 5 years to get an approved I-526. So it takes a very long time, unfortunately. And we have helped a number of clients sue the government because we think 5 years is absurd, and we think that they should do their job quicker. And we, by and large, have been successful with those lawsuits. So, so the government, we believe, has an obligation to process these certainly in less than 2 years, even though their estimate right now is 5 years. So that concludes our EB-5 section. Just to give a brief recap, because I am aware of the time, we covered the E-2 visa, which has a lower investment amount, but is an excellent option for those who have treaty country nationality. As long as you're employing 3 full-time equivalent workers within 5 years, that is the employment requirement. The National Interest Waiver, which GA covered, you have to show that the endeavor is in the national interest, that you are well positioned to advance it, and that labor certification should be waived, which is generally a quite easy requirement to show. The International Entrepreneur Rule, which is really up in the air right now, may take a long time, and we're not sure what the approval rate will be. But if you're not from an E2 treaty country, or if your equity will be diluted below 50%, might be your best option. And finally, the EB-5 green card, which is for those who have either $800,000 or $1,050,000 to invest into either a direct investment opportunity or a regional center. You have to show that you'll employ 10 full-time employees over the 2-year period after your I-526 is approved. And yes, the wait time is very long, but you can now file an I-485 at the same time if you're within the US. So we have covered all of our questions. Thank you all for the great questions and for joining us today. Do keep an eye out for the email that GA mentioned with a link to, among other things, our YouTube channel, where we try to put some really good information for you all. GA, thank you for sharing your expertise. So everyone have a wonderful day, and we hope to see you on future webinars.
Thank you, Dustin. Thank you, everyone.